Good morning. Myself, Dr. A.M.V. Dukhan Kumar, Assistant Professor, Department of Commerce, P.B. Siddhartha College of Arts and Science. Today, we are going to discuss about types of contracts. So, basically, the contracts are classified into three categories. On the basis of formation, it has classified as express contracts, implied contracts, and quasi-contracts. On the basis of performance, it is classified into executed and executory contracts. On the basis of validity, it is further classified into valid contracts, void agreements, illegal agreements, void contracts, voidable contracts, and unenforceable contracts. Based on the formation of contracts, we can discuss about all the subcategories in a detailed way. The contracts can be subclassified into three categories on the basis of how they were formed or incorporated. First one is express contracts. An express contract is a contract which is expressed in words spoken or written under Section 9 of Indian Contract Act 1872. An express contract can be subdivided as written contracts, oral contracts, and e-commerce contracts. Coming to written contracts, where the parties enter into a written contract by mutually agreeing upon the terms and conditions of the contract. Coming to oral contract, a contract can be expressed orally also. It will be enforceable by law unless required by another law to be in written. Coming to e-commerce contracts, where the parties to a contract express their intention to enter into a contract via internet, such contracts are known as e-commerce contracts. Next one, implied contracts. A contract which is not expressed in words but is implied from the circumstances of the case or the conduct, that is nothing but the behavior of the parties. Quasi-contracts. As the name suggests that a quasi-contract is a contract which is not formed by the parties to the contract but is enforced on the parties to the contract by the court of law. According to the performance of the contracts, it is classified into two categories. So, performance of the contracts decides the completion of the contract. So, it is classified into executed contracts and executory contracts. Executed contracts. In a contract where both the parties performs their respective promise or obligation, the contract is said to be completely executed. Executory contracts. In a contract where performance is due or incomplete is said to be executed. It is further classified into two types: bilateral and unilateral, where both the parties of the contract do not perform their part of obligation is called bilateral executory contract, where one party has to perform but the other party did not perform. Such a contract is called an unilateral executory contract. Based on the validity of the contracts, whether an agreement becomes enforceable by law depends entirely on its validity in the eyes of the law. The contracts can therefore be classified on the basis of validity as below. Valid contracts, according to Section 2, subsection H, void agreements, according to section 2, subsection G, illegal agreements. Void contracts according to section 2, subsection J, voidable contracts according to section 2, subsection I, unenforceable contracts. Valid contracts. An agreement enforceable by law is a valid contract. That means an agreement which satisfies all the essentials according to section 10 of Indian Contract Act 1872 of a valid contract becomes enforceable by law, and this is called a valid contract. Void agreements. An agreement not enforceable by law is a void contract. An agreement which does not fulfill all the 10 essentials of a valid contract can become a void agreement because of the lack of any of those essentials, such as an agreement without consideration is void, an agreement with minor is void, an agreement whose meaning is uncertain is void. Illegal agreements. An agreement, the object or purpose of which is unlawful, is called an illegal agreement. All illegal agreements are not enforceable by law because of their illegal purpose, and therefore all illegal agreements become void agreements. Void contracts. A contract which ceases to be enforceable by law becomes void when it ceases to be enforceable. A void contract is a contract which was a valid contract when formed, but because of their supervening impossibility of performance, today it has become impossible to performance. Hence, it is void. The performance in a void contract may be excused due to performance is rendered impossible by any change in law. Performance is rendered impossible because of restriction of subject matter. Performance is rendered impossible because of death of a party. Voidable contracts. An agreement which is enforceable by law at the option of one or more of the parties thereto, but not at the option of the other or others, is a voidable contract. In such a contract, where consent of one of the parties was not free, such party is called aggrieved or an innocent party. The aggrieved party has two options. Either it may continue the same contract or it may avoid the contract. If the aggrieved party wants to continue the contract, then the contract becomes enforceable and it is a valid contract. But if the aggrieved party wants to avoid the contract, then it is then it becomes a voidable contract. Once the aggrieved party avoids the contract, then the parties to the contract are restored to their original positions. That is, if a party suffered losses, then these losses have to be compensated. And if a party had some benefits, then these benefits have to be returned back. Unenforceable contracts. An unenforceable contract is a contract which is not enforceable by law because of some technical defect existing in it. Once the defect is rectified, the contract becomes enforceable by law. Like some contract should be duly registered as required under Section 17 of the Indian Registration Act. If such a contract is formed without registration, it would be called an unenforceable contract until it got registered. Once it is registered, it becomes a valid and enforceable contract. Thank you.